in the name of family law.
We're here this morning with Kent Wood, the owner and lead attorney of Wood & Associates in Lansing, Michigan. He's a family law attorney, and we're going to talk today about spousal support. Welcome back, Kent.
Yes, thank you, Lisa. So we have clients that'll come in and need, going through a divorce, and there's going to be an issue with spousal support. And I often argue with the other attorneys on how many factors there are. Are there 10 factors? Are there 14 factors? 11 factors, right. But I always kind of tell clients it's really about what the need is. It's not supposed to be about fault. It's not supposed to be about getting payback for all the sacrifices you made. It really is, what is the need and ability to pay at the time of the divorce. Mm-hmm. The other thing I kind of deal with clients in that matter is I kind of give them the 5-10 year rule, where if your marriage is under 5 years, you're kind of looking at probably not getting an award. But if you've been married more than 10 years, it's usually a question of how long and how much. Mm-hmm. And I just wanted to share a couple of the cases that we've dealt with that kind of express some of the factors there. If that's okay.
Absolutely. Let's talk about some of the factors in those cases. Right.
So I had one case where they married 30 plus years. So clearly, long-term divorce. They had children. The wife stayed home, raised the children. But they were very successful financially at one point in their life. But at this point, not so much. They had a total of about $3,500 monthly income. She was on Social Security disability. They were getting divorced, and she needed help. She definitely needed help, and that's one of the factors: need of the party. She needed help specifically with even just paying health costs, right? Especially at the
and when you get divorced, your expenses increase because now instead of having one home and one set of expenses, you have two homes.
Yes.
And two sets of expenses.
Absolutely, and I often tell clients that the court wants everybody to be okay, but they want almost to make sure that you can afford your life, right? So there has to be an ability to pay, and this is the situation. This gentleman had about $2,300, could barely pay his own personal expenses. I'm talking rent, heating, cooling, food, and had nothing that he could really pay over. So even though there was a clear need, there was nothing that he could do at that point.
And so what did the judge do?
The judge ordered that no support was to be entered because she was going to need help from state assistance, and then he would have an opportunity to basically not need state assistance, and that was kind of the ruling there.
And I've seen cases that have come to me as an appellate attorney where the trial judge does an award of support such that one spouse is basically living in the same standard that they were during the marriage, and the other spouse, the one that's working, is actually working basically just to pay support. I've also seen the opposite where one party feels that the other one, is the one who's paying support, lives the same standard. They're able to have a luxury lifestyle, and the other spouse, the non-moneyed spouse, is the one that's like scrimping and saving because their spousal award is so small. Like there's just this imbalance and disparity that it's inconsistent, I guess is the word I would use.
And I think that means you'd have to have a good attorney or someone to assist you in that process, because there are all these factors, and there are factors that get reviewed by judges that probably aren't supposed to be. But the good part is if a judge orders spousal support, it is always modifiable. I mean, it can be changed at any point later because of circumstances change. Incomes go up or down, needs or health issues change, that go up, down. Just that all switches and changes. The only way to get a non-modifiable order is if you agree in advance as part of the judgment of divorce at that time, with both sides agree that it's going to be non-modifiable.
So I think you bring up two important points. One, that it's modifiable if the judge orders it. That means even if the judge says you only get support for 10 years and it's a certain amount and it ends after 10 years, even after it's ended, the other spouse could come back to court and say, you know what, I still have a need.
Oh, absolutely.
And even though they think in the judgment of divorce it says 10 years, well, that really doesn't mean 10 years.
No, it truly is about the need is the ultimate thing, and usually a health need is the pushing matter. Yeah. We had a case where parties were married 4 years, so it was under my 5-year rule. Mm-hmm. But the one spouse made close to about $8,000 a month. The other spouse couldn't hardly work because there was an accident where she suffered. It's called Bridget Abuser, an attorney in my office, really great. Had as a nursing background, always says TBI, and she's traumatic brain injury. So this poor individual had a traumatic brain injury and couldn't work. Was young, they hadn't been married very long, but couldn't work. So because of the need, they were awarded 10 years of support and potentially continue past that.
Well, the need coupled with the other spouse's ability to pay, right?
Right. Ability to pay it. That was a major factor in those two.
Well, let's talk a little bit more about non-modifiable support, because this is really, I think, an opportunity for a trial attorney to give some certainty to their client if they can negotiate non-modifiable. Do you have any examples to share with us on that?
Of non-modifiable, yes, we actually try to pursue a non-modifiable support because it actually gives certainty not to the payer of support, but also gives certainty to the person receiving support. Mm-hmm. Because usually it's a transition money. The party needs time to transition back into what I call single life.
And the workforce potentially.
Right. And the workforce, so they maybe need to go back to schooling or re-education and such. But it's just, how do I go back to setting up my own bills, setting up my own house? That's going to happen. There's going to be a stress there, and there's going to be some help there. We often try to negotiate even lump sum payments as opposed to periodic spousal support payments, because it's just easier to deal with that way. And they keep changing the tax rules when it comes to support and who has to pay taxes on that money. I think it's now that the receiver has to pay the taxes on that money. It used to be the payer paid. And so those all have to be kind of figured out. But if you can get some certainty, then you know where you need to be and how much time you need to get there.
Right. So warning, because I had a case that was a substantial amount of non-modifiable support that was awarding the wife in that case with the fact that the husband was keeping this ongoing business, a very successful business. And instead of getting a portion of the business, she got a non-modifiable award that was being paid in periodic payments over a certain period of years. And it was a significant monthly amount. When the business collapsed, the husband went back to court and convinced the trial judge to set aside a non-modifiable award. And we did win that issue on appeal in a published opinion, but the amount of effort that went into preserving that award was significant.
Wow. Okay. So fortunately, I've been in a situation where a non-modifiable award has not been challenged, but we often try to kind of draft around the statute to protect that from happening.
That's exactly right. I think sometimes if the wording is not just right, it's got to be very careful in those situations. And I think probably what I see are the rare exceptions. Hopefully, most of the non-modifiable provisions aren't that complicated.
Right. But yes, we're just trying to help people get back on their feet to make sure they're okay after the divorce is filed.
And just really quickly, other factors that the courts consider are like age of the parties, their ability to work.
Ability to work, income, education. Has anybody spent a lot of money from the estate, or somebody has a gambling issue or something where they liquidated assets?
And the judge can consider one party's fault in the breakdown of the marriage.
Yes, they can, but only slightly.
That's what it should be. That's what it should be. Right. Well, wonderful, Kent. Thank you for sharing this helpful information.
Well, thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC.